convicted of the commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. The law provides that criminal action shall be indicted in the county in which the crime was committed. Venue, that is, the crime that was committed in Athens, Clarke County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt, just as any element of the offense. Venue must be proved by direct or circumstantial evidence, or both. A person commits murder when that person unlawfully and with malice aforethought, either expressed or implied, causes the death of another human being. Express malice is that deliberate intention unlawfully to take away the life of another human being, which is shown by external circumstances capable of proof. Malice may, but need not, be implied when no considerable provocation appears and when all the circumstances of the killing show an abandoned and malignant heart. It is for the jury to decide whether or not the facts and circumstances of this case show malice. To constitute murder, the homicide must have been committed with malice. Legal malice is not necessarily ill will or hatred, but it is the unlawful intention to kill without justification, excuse, or mitigation. If a killing is done with malice, no matter how short a time the malicious intent may have existed, such killing constitutes murder. Georgia law does not require premeditation, and no particular length of time is required for malice to be generated in the mind of a person. It may be formed in a moment, and it may instantly a mortal wound may be inflicted. Yet if malice is in the mind of the accused at the time of doing the act or killing and moves the accused to do it, such is sufficient to constitute homicide as murder. Proof of particular motive is not essential to constitute the crime of murder. Evidence of motive, if any, is admitted for your determination as to whether or not it establishes the state of the defendant's mind at the time of the alleged homicide. A person commits the offense of criminal attempt to commit when, with the intent to commit murder, he performs any act which constitutes a substantial step toward the commission of that crime. A person also commits the crime of murder when, in the commission of a felony, that person causes the death of another human being with or without malice. Under the laws of Georgia, aggravated assault with a deadly weapon, aggravated assault upon a peace officer with a deadly weapon, and possession of a firearm by a convicted felon and aggravated assault are felonies and are defined as follows. Any person who has been convicted of a felony by a court of this state or any other state and who possesses any firearm commits the crime of possession of a firearm by a convicted felon. The offense of armed robbery is a felony under the laws of this state and is defined as previously stated. A person commits the offense of aggravated assault when that person assaults another person with a deadly weapon, or that person assaults another person with any object that, when used offensively against a person, is likely to result in serious bodily injury. To constitute such an assault, actual injury to the alleged victim need not be shown. It is only necessary that the evidence show beyond a reasonable doubt that the defendant attempted to cause a violent injury to the alleged victim or intentionally committed an act that placed the alleged victim in reasonable fear of immediately receiving a violent injury. The state must also prove as a material element of aggravated assault as alleged in this case that the assault was made with a deadly weapon or an object, device, or instrument that, when used offensively against a person, is likely to result in serious bodily injury. A knife, if and when used to make an assault on another person, is not a weapon capable of producing serious bodily injury per se, but may or may not be a weapon capable of producing serious bodily injury depending upon the manner in which it is used and the circumstances of the case. You may or may not infer the serious injury producing character of the instrument in question from the nature and extent of the injury, if any, inflicted upon the person allegedly attacked. Whether or not, under all the facts and circumstances of this case, the knife alleged in this bill of indictment to have been used in making the assault upon the alleged victim did, in fact, constitute a weapon likely to cause serious bodily injury is a matter to be decided by the jury from the evidence in this case. A firearm, when used as such, is a deadly weapon as a matter of law. A person commits the offense of aggravated assault upon a peace officer when that person knowingly commits aggravated assault with a deadly weapon or commits aggravated assault with intent to murder upon an officer while that officer is engaged in or on account of the performance of official duties. The intent to murder is a material element of aggravated assault as charged in this case. In deciding the question of intent, you may consider all the facts and circumstances of the case, as well as the character of the weapon used and the manner in which it was used, if you find that a weapon was used. An essential element of the offense of aggravated assault on a peace officer is that the accused knew that the alleged victim was a peace officer. This may be shown by evidence of circumstances that would cause a reasonable person to know that the alleged victim was a police officer. A person commits the offense of aggravated assault, as I have previously defined it, when that person assaults another person with intent to rob. The intent to rob is a material element of aggravated assault as charged in this case. In deciding the question of intent, you may consider all the facts and circumstances of the case, as well as the character of the weapon used and the manner in which it was used, if you find that a weapon was used. A person commits robbery when, with the intent to commit theft, that person takes property of another from the person or the immediate presence of another by placing such person in immediate serious bodily injury in fear of immediate serious bodily injury to that person or to another. The essential elements of the offense that the state must prove beyond a reasonable doubt are that the taking was done with the purpose to commit theft against the will of the person robbed and by placing such person on another in fear of immediate serious bodily injury to himself or herself. A person commits armed robbery when, with the intent to commit theft, that person takes the property of another from the person or the immediate presence of another by use of an offensive weapon or by any replica, article, or device having the appearance of such a weapon. An offensive weapon is any object, device, or instrument that, when used offensively against a person, is likely to result in death or serious bodily injury. The character of a weapon may be established by direct or circumstantial evidence and the instructions that I have previously given you. A person commits kidnapping when that person abducts or steals away any person without lawful authority or warrant and holds such person against such person's will for the offense of kidnapping to occur. Slight movement shall be sufficient, provided, however, that any such slight movement of another person which occurs while in the commission of any other offense shall not constitute the offense of kidnapping if such movement is merely incidental to or necessary to the completion of such other offense. Movement shall not be considered merely incidental to another offense if it conceals or isolates the victim, makes the commission of the other offense substantially easier, lessens the risk of detection, or is for the purpose of avoiding apprehension. When during a kidnapping the person abducted receives any bodily injury, however slight, then that constitutes kidnapping with bodily injury. It is not necessary that the state show that the defendant directly committed, caused, nor even intended the injury to the alleged victim, nor that the act of kidnapping directly produced the injury. However, the evidence must show beyond a reasonable doubt that any such injury was caused during a period of and in some way connected to the alleged abduction. A person commits the offense of false imprisonment when, in violation of the personal liberty of another, he confines or detains such person without legal authority. A person commits the offense of hijacking a motor vehicle when such person, while in the possession of a firearm or weapon, obtains a motor vehicle from the person or presence of another by force and violence or intimidation. Motor vehicle means any vehicle which is self-propelled. Firearm means any handgun, rifle, shotgun, or similar device, or weapon which will or can be converted to expel a projectile by the action of an explosive. Weapon means an object, device, or instrument which, when used against a person, is likely to result in serious bodily injury or death, or any replica, article, or device having the appearance of such a weapon. You should consider whether the weapons are capable of causing serious bodily injury according to the instructions I have previously given you. A person commits the offense of burglary when, without authority, that person enters or remains in any building or dwelling place of another, or any room or part of it, with the intent to commit a felony. Offenses of aggravated assault, kidnapping, and false imprisonment constitute felonies. To constitute the offense of burglary, it is not necessary that the alleged felony actually occur or be accomplished. It is only necessary that the evidence show beyond a reasonable doubt the accused did, without authority, enter or remain in the building or dwelling place of another with the intent to commit the alleged felony. A person commits the offense of possession of a firearm during the commission of a felony when the person has on or within arm's reach of this person a firearm during the commission of or any attempt to commit a felony, which is any crime against or involving the person of another, the unlawful entry into a building or vehicle, or a theft of the vehicle. The offenses of armed robbery, malice murder, felony murder, criminal attempt to commit murder, kidnapping with bodily injury, false imprisonment, hijacking a motor vehicle, burglary, aggravated assault with intent to murder, aggravated assault with intent to rob, aggravated assault upon a police officer with a deadly weapon, and aggravated assault upon a police officer with intent to murder are felonies under the laws of this state as previously stated. A person commits the offense of possession of a knife during the commission of a crime when the person has on or within arm's reach of this person a knife having a blade of 3 or more inches in length during the commission of or any attempt to commit a felony, which is any crime against or involving the person of another or a theft of a vehicle. The offenses of armed robbery, aggravated assault with intent to rob, hijacking a motor vehicle, and kidnapping with bodily injury are felonies under the laws of this state and are defined as previously stated. The defendant contends that he was not present at the scene of the alleged offenses set forth in counts 50, 51, 52, and 53 at the time of its commission. Alibi as a defense involves the impossibility of the defendant's presence at the scene of the alleged offense at the time of its commission. Presence of the defendant at the scene of the crime alleged is an essential element of the crime set forth in this indictment. The burden of proof rests upon the state to prove such beyond a reasonable doubt. Any evidence in the nature of alibi should be considered by you in connection with all the other evidence in the case. If in doing so, you should entertain a reasonable doubt as to the guilt of the accused, it would be your duty to acquit the defendant. On the other hand, if you believe from the entire evidence the defendant is guilty beyond a reasonable doubt, you may convict. An affirmative defense is a defense that admits the doing of the act charged, but seeks to justify, excuse, or mitigate. Once an affirmative defense is raised, the burden is on the state to disprove it beyond a reasonable doubt. Justification is a defense to prosecution for any crime. A person is justified in threatening or using force against another person when and to the extent that he reasonably believes that such threat or force is necessary to defend himself or a third person against the other's imminent use of unlawful force. A person is justified in using force that is intended or likely to cause death or great bodily harm only if that person reasonably believes that such force is necessary to prevent death or great bodily injury to himself or a third person, or to prevent the commission of a forcible felony. A forcible felony is a felony that involves the use or threat of physical force or violence against the person. A person is not justified in using force if that person initially provokes the use of force against himself with the intent to use such force as an excuse to inflict bodily harm upon the assailant, or is attempting to commit, is committing, or is fleeing after the commission or attempted commission of a felony. The offenses of kidnapping, kidnapping with bodily injury, possession of a firearm by a convicted felon, armed robbery, aggravated assault with intent to rob, aggravated assault, and hijacking a motor vehicle are felonies under the laws of this state as previously defined. In applying the law of self-defense, a defendant is justified to kill or use force against another person in defense of self or others. The standard is whether the circumstances were such that they would excite not merely the fears of the defendant, but the fears of a reasonable person. For the killing or use of force to be justified under the law, the accused must truly have acted under the influence of these fears and not in the spirit of revenge. What the facts are in this case is a matter solely for you, the jury, to determine, given all the circumstances of the case. The use of excessive or unlawful force while acting in self-defense is not justifiable, and the defendant's conduct in this case would not be justified if you find that the force used exceeded that which the defendant reasonably believed was necessary to defend against the victim's use of unlawful force, if any. A person has the right to defend himself or herself, but a person is not justified in deliberately assaulting another person solely in revenge for a past or previous wrong, regardless of how serious the past or previous wrong might have been when the episode involving the previous wrong has ended. Such a person is not justified in acting out of revenge by deliberately seeking out and assaulting the alleged wrongdoer. If you find from the evidence in this case that the defendant used force against the alleged victim named in this indictment in order to prevent an impending wrong that the defendant reasonably believed was about to be committed by such other person, and that the defendant reasonably believed that such force was necessary in order to prevent such impending wrong, death, or great bodily injury to the defendant, or to prevent the commission of a forcible felony, then that use of force will be justified, and it will be your duty to acquit the defendant. On the other hand, if you believe beyond a reasonable doubt from the evidence in this case the defendant used force against the alleged victim named in the indictment in the way and manner alleged in the indictment for the sole purpose of avenging a past or previous wrong, regardless of how serious such previous wrong may have been, and not for the purpose of preventing an impending wrong, death or great bodily injury to the defendant, or to prevent the commission of a forcible felony, then you would be authorized to convict the defendant. A police officer is authorized to use in making a lawful arrest only that degree of force that is reasonably necessary to accomplish the arrest. The mere fact that a lawful arrest is being made does not give the officer the right to use excessive force or unlawful degree of force on the person being arrested. A person being arrested, even though the arrest itself is lawful, has the right to resist the use of excessive and unlawful force by making the arrest to the extent that the person reasonably believes that the degree of resistance used is necessary to defend against the officer's use of unlawful or excessive force. In resisting, the person being arrested would not be authorized to use force that is unlawful or disproportionate to the amount of force necessary to prevent the unlawful force being used against the person. An arrest for a crime may be made by a law enforcement officer without a warrant if the offense is committed in such officer's presence or within such officer's immediate knowledge. The offendant is endeavoring to escape or for other cause where there is likely to be failure of justice for want of a judicial officer to issue a warrant. A peace officer may use deadly force to apprehend a suspected felon only when the officer reasonably believes the suspect possesses a deadly weapon or any object, device, or instrument which, when used offensively against a person, is likely to or actually does result in serious bodily injury. When the officer reasonably believes that the suspect poses an immediate threat of physical violence to the officer or others, or when there is probable cause to believe that the suspect has committed a crime involving the infliction or threatened infliction of serious physical harm. Peace officers may use such reasonable, non-deadly force as may be necessary to apprehend and arrest a suspected felon on misdemeanor. Probable cause for an arrest without a warrant exists when the facts and circumstances within the meaning of the arresting officer's knowledge are sufficient to warrant a belief by a man of reasonable caution that a crime has been committed. To justify an arrest without a warrant, an officer need not see the act which constitutes the crime take place if by any of the officer's senses the officer has personal knowledge of its commission. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Athens, Clarke County, Georgia, did commit one or more of the offenses as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. For each charge, you find the defendant guilty of committing. If you do not believe that the defendant is guilty of one or more of the offenses, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant of that charge, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. You are only concerned with guilt or innocence of the defendant. You are not to concern yourselves with punishment. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of the case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Whatever your verdict is, it must be unanimous. That is agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. The court has prepared a verdict form for you. Simply write in this blank space provided for each count whether you, the jury, find the defendant guilty or not guilty. After reaching your verdict on each charge, the foreperson should print his or her name in the space provided of the verdict form, sign it, and date it. That needs to be done in ink. One of your first duties in the jury room will be to select one of you to act as foreperson who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, consult with one another, consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. You can now retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence that has been admitted in the case. Now, I will tell you that will take a few minutes for us to gather up this evidence and all. But, so don't start your deliberations until you have that. But the 12 jurors will go to the jury room. The alternates will go somewhere else. And I'm going to give you the initials of the alternates. Alternate 1, CJM. Alternate 2, JCH. Alternate 3, BCS. So the 12 of you can go to the jury room. And the bailiff will escort before your alternates to another place. You drop the camera, please. Thank you.
required element of conviction of a felony for the offense of count 5 for not being a purpose actually would apply to count 3 and 5, as well as 52 and 54. Because that's you have a felony murder during the commission of possession of firearm by convicted felon, as well as possession of firearm by convicted felon in counts 3 and 5, as well as 52 and 54. So it didn't indicate particularly the order of our rate, just indicated count 5 like that. So I think that. I think that's the only thing we noted as we were going through that, Judge, and I think that should be corrected like that.
Thank you, Mr. Hood. Yes, we bring them back out, we charge them on prior convictions.
I believe you're probably required to, Judge. Of course, I know you're going to give them a copy of it, but I think you're probably required to do that at least on that case.
This wasn't mentioned, sorry.
Any objection, Mr. Hood, bring them back out and recharge them on that count?
That's all we judge.
All right. I'm going to bring them back out and recharge them on that, and then we'll change the
Yes, sir.
the written one. So it will read, the last sentence will read, you may consider this evidence only insofar as it may relate to attacking the credibility of the witness and for the required element of conviction of a felony for the offense in counts 3, 5, 52, and 54, and not for any other purpose or count. I'm going to read the whole thing, but
And, Judge, I apologize if I didn't catch that during the church conference, but there are, as I remember here, as I go through, there are possession of a firearm during the condition of a crime that actually lists that prior conviction as well. Because it provides, if they're convicted of that, and I'm referring to count 55, and I just thought of this, frankly, because that was alleged in those counts 55, 56, 58, 59, 60, 61, 62, 63, 64, 55, 56, 67, 68, 69,
215
To the
prior
ones, yes, sir,
conviction.
and I'm sorry, I didn't catch that before, and I apologize, but I didn't catch that. So it's, I think it's 55 through 69, not counting 57, which involves a ninth. So, I apologize. I
Let's
didn't-
take a moment and be certain.
Yes, sir.
So you're asking under charge on page 15 to add counts 3, 5, 52, 54, 55, 56, 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, and 70.
You may say 3, 5, 52, and 54 through 56, and 58 through 70 may be one way to do it, or unless you want to delineate each count.
I'm just saying.
Okay, and I,
You want to be heard on that, Mr. Wood? No objection. Anything else?
yes, sir.
Mr. Wood, any other objections to the charge as written? Okay, ask the jury to come back out, and we'll need the alternates as well. Okay. sorry, gentlemen, I misspoke on one of the charges. I need to read that charge again. The correction will be made in the copy that you as well. You have received an evidence of prior convictions of the defendant and certain witnesses. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and for the required element of conviction of a felony for the offense in counts 3, 5, 52, 54, 55, 56, 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, and not for any other purpose or count. The 12 may return to the jury room, and the alternates will go for their place. I ask again, any other objections to the charges given?
That's not law.
Mr. Hood?
No, sir.
All right. If you all want to, we'll get the evidence, let's, together. In the verdict form, here's the verdict form to go back with them.
Yes, sir.
I think it should be the same one that you all have.
Yes, sir.
Mr. Wilson is substituting that page that we just recharged on. I think you have the, I believe he's already given you the charges to go back with them.
Yes, sir.
I'm going to be asking that you look at those.
I have not seen the ones that copy they're getting, because the ones we have the headings. I have not gotten one without the headings.
We'll have those.
Get that when that's fine, that's fine, I have not.
Because I do want y'all to look at those before they go back. The
Yes,
ones that they're going to see. I'll ask on the record about those.
Assume it's page by page, what you gave us, just deleting the headings.
That's
I
correct.
assume that's correct, so it shouldn't be that hard to read.
Yeah, y'all will look at those.
Yes, sir.
The indictment.
Ms. Vogel has all her evidential stuff, I think she's already gone over that, which is a good bit, but I think she's gonna go back through that and have to see those parts that are in this one.
I'll go ahead and, this is the original indictment, it will go back with them as well. All right. So my proposal would be, for the state to first look and confirm that those are the items that go back, and then let you step back, and then Mr. Hood will be able to look at those as well.
Sure.
And I'll be asking both of